Welcome. Thank you for joining us, everybody. My name is Lori Berman. I am the Vice President of Membership and Development for the Small Business Association of Michigan. Very happy to have you here today. Thank you for joining us. We do these webinars each month for your educational and learning pleasure. There will be another one in December that's a cybersecurity one, so watch the website for more information on that. Today's webinar, I'll give you the topic title, When Vengeful Things About Your Business Get Posted Online. That's today's subject. And our speaker today is Brian Wassam. Brian, welcome. Brian litigates disputes and counsels clients in a wide range of commercial and intellectual property matters. He's developed a particular focus in matters of creative expression, commercial identity, and privacy, which spans the legal doctrines of copyright, trademark, privacy, publicity rights, advertising, journalism, and related fields. Brian is a futurist at heart, and he has become a globally recognized thought leader in the brand new legal issues raised by augmented reality and other cutting-edge emerging media. We are really pleased to have Brian here today. A couple of housekeeping matters. We will be recording this session. If you would like to refer someone else to it, we'll be posting it on our website next week. If you need to watch it again, it will be available on our site next week. If you have questions during today's presentation, please feel free to post them on either the chat feature or the Q&A. I will be monitoring those, and we'll be going over those questions at the end. So without further ado, I will turn it over to Brian. Brian, thanks for being here.
So thanks, Lori, and welcome to everyone. To recap what I've been saying to myself, the materials you're about to discuss are drawn from my own personal experience in advising clients in the social media space. Now, I've taken liberties with the details to not reveal anything confidential, but they are some of the many examples out there of real life businesses, many of them in Michigan, encountering day-to-day issues with social media conversation. And originally, I think the original thought for this process was this presentation was going to be restricted to what employees post, and I'm going to talk quite a bit about what employees post about businesses because they're often the source of problematic posts. But I'm not going to limit it to that because businesses encounter problems with content from all sorts of people that has to do with their business, and that causes them consternation in running their business. So I've charted out what I think are from my experience, the largest buckets of legal problems, if you will, the areas of law that are most relevant to this conversation. But it's certainly not an exclusive list. And if there's a topic or an experience that you have in mind that I don't cover in this presentation, feel free to chime in at the end with any questions, and we should have plenty of time left over at the end for that Q&A process. So what I've charted out here are four main areas of legal issues, and they're listed here on the slide. The first I'm going to talk about is employment law, and that really relates to what can we do about posts that are by or about our current employees, and how do our restrictions under employment law affect our options in that circumstance. The second is more generally and probably my most frequently encountered topic when advising clients in the social media space, and that's posts that impact our reputation, whether that's of a person or of a company. We put that under the header of defamation. We'll talk about that. Third is intellectual property, which includes copyright, trademark, and the like, and that comes up quite often as well. And then finally, invasion of privacy. So heading off to our first topic, which is employment law. Now, the reason why it matters if the folks posting this objectionable content are current employees or not is because they have certain rights under the employment law. And the source of employment law that comes up most frequently, and again, this is not exclusive, there are other sources of law out there, but the one that comes up most frequently in the context of the social media conversation is the National Labor Relations Act, which is enforced by the National Labor Relations Board. And that is particularly Section 7 of that act, which deals with the right to protected concerted activity. And you see the text of the full section up there on the screen, and we're focusing just on the bolded portion. And this is where a whole host of social media related cases have come from. And this is the idea that federal law guarantees to every employee the right to interact with each other, the right to act cooperatively to improve their workplace conditions. This is true whether or not they're a member of a union, and it's true across just about all industries. Even if you're a small business, chances are that you are regulated by this section. The standards for applying the act are generous. For the retail industry, for example, if you are a retailer of any type, as long as you have a gross annual volume of business of $500,000 or more in a year, you are covered by this act. If you're not a retailer, then the board looks at your either inflow or outflow over state lines. If you are doing business in goods or services across state lines in either direction in an amount of at least $50,000, then again, you're covered by this act. So, and there are particular exemptions for certain industries. Agriculture, for example, is largely exempted from this act, and we have a lot of agricultural businesses here in the state. So not everybody has to worry about this, but there are similar protection under some state laws, and most of the folks watching are going to be protected by this act. They're going to be covered by the principles required by the National Labor Relations Act. So what does that mean in the social media context? We've set the baseline for the law that applies, but what does it mean in terms of what that right covers, what it gives employees the right to do? Now imagine 20 years ago, if an employee of your business went out and bought a full-page newspaper ad or a billboard on the side of the road and aired his grievances about your company and his workplace conditions. I don't think that there's any question that we would naturally assume that that employee was way off the reservation and would be fired. I mean, that's the type of thing that undermines his employer's business and is just not the type of employee that employers would want to have around in that circumstance. But contrast that to what's available now, which is with a few keystrokes and clicks of a mouse, those same grievances, those same complaints can be aired to a global audience on Facebook, Twitter, and the like, and huge order of magnitude more people are likely to see that message than if it had been contained in a newspaper ad or a billboard on the side of the road. Nevertheless, the protections, the legal protections for that activity are even greater and even stricter nowadays. And this law has built up in the last 7-8 years, since about 2010, 2011. And we'll note at the end, there's been some fluctuation in the direction of this case law. But right now, we're still dealing with case law that was largely developed by the National Labor Relations Board under the prior administration. And that's still the precedent that we are dealing with as our baseline. So, for example, just to give you a series of examples from the actual case law, there was an employee of the Thomson Reuters Corporation, the news corporation, that wrote on Twitter. He's complaining about the way that his company deals with unions, and he said one way to make this place the best place to work is to deal honestly with guild members, implying that his employer didn't deal honestly with its employees. He got a call from the bureau chief informing her of the company's policy that we're not supposed to say anything damaging to the reputation of the employer. That employer, Thomson Reuters, was punished, was in turn disciplined by the National Labor Relations Board for chilling this employee's right to protected concerted activity. In other words, this employee's tweet was seen as in coordination with other employees to promote better relationships between the union and the employer, and thus protected by federal law. And the policy that forbid such posts was deemed to be invalid. The action taken to enforce that policy was deemed to be a violation of law. There's another case that went all the way up the chain in terms of labor law, and set a similar precedent. It's a New York nonprofit rather, called Hispanics United. 5 employees of this nonprofit were terminated based on their Facebook posts. And it started with one Facebook post where an employee complained that the organization and its employees, her coworkers, didn't do enough to help the organization's clients. And then other employees jumped on the bandwagon, responding and complaining about all manner of workload conditions, staffing issues, and things of that nature. Now, the board, again, repeatedly ruled in this case that this would constitute a protected concerted activity, and that the employer had violated the law for firing these employees over this Facebook post. There's another one that got a similar amount of attention. And this dealt with an employee at a BMW dealership in Chicago. This guy got himself in trouble for a couple of reasons. First, he posted some pictures on Facebook making fun of a car accident that happened across the street at the competing Land Rover dealership. Apparently, the dealer across the street crashed one of its Land Rovers trying to set it up or something, and made a scene on the side of the road. He posted about that and mocked the situation. But he also posted a complaint about his own dealership and their practices of how they put on customer sales events. And in particular, he complained that his employer only served hot dogs and water at their customer sales event, and that this was beneath the dignity of a BMW dealer. He was fired, and at the first time around in the appeal process, that action was struck down on the grounds that his complaints about the hot dogs was a protected concerted activity. The federal law protected his ability to complain about his employer's hot dogs online. Ultimately, though, his termination was upheld, not because they disagreed with that finding. The hot dog post was still protected, but because the board decided that he was actually fired for making fun of the Land Rover dealer. That's not something that's protected by federal law. These types of rulings are made not only in terms of specific instances of punishment or termination, but also when reviewing employers' policies. So, for example, Costco and other companies have all had their social media policies stricken by the board for having lines in it such as prohibiting statements that may damage the company or damage any person's reputation. The idea here being that if these protections are too broad, then something that is a legitimate complaint under federal labor law could still be interpreted as damaging the company's reputation, and the federal labor rights trump that concern. Not all. So at this point, the relevance to this presentation is that a lot of times when employees post things vengefully, when they post things that are directed at the company's reputation or directed at complaining about their workplace conditions, things that we chafe at as business owners, there may not be anything we can do about that because these federal labor laws protect that activity. Contrast those examples, though, just to let you know that not everything objectionable by a current employee is protected. There are cases in which terminations or disciplinary actions were in fact upheld. One, for example, the Arizona Daily Star newspaper, one of its reporters tweeted out several sarcastic posts about his viewers. For one, saying, "You stay homicidal, Tucson," and in mock complaining that there had been no murders overnight in Tucson, indicting his readership for being a violent city. And that had nothing to do with his workplace conditions. That was just obtuse, and so he was properly fired for that. Another case in which a bartender actually did complain about things related to work that stemmed from his workplace experience, but it was complaints about particular coworkers like waitresses, and that he wasn't that they weren't required to share their tips with him. This was an online post directed to a relative complaining about his experience at work. It didn't involve any other coworkers, any other employees, or the employer itself. So the board ultimately decided this is just him in his personal vitriol. This doesn't have anything reasonably related to do with improving his workplace conditions. Now, there are a number of other examples. I won't go into all of them. I think that kind of covers the spectrum enough to get an idea of just how difficult it can be to take action about posts by current employees, at least under the law as it exists. So every change of administration, there are new appointees to the National Labor Relations Board. And based on some of the new appointees from the current administration, some of these precedents are likely to retract a bit. In other words, they're likely to become a little bit more employer friendly in terms of what you can do about social media posts. So the most recent guidance we have from the NLRB on this topic came about 6 months ago. And these are from that report. And then it didn't have anything to do specifically with social media, but these establish some broad principles that we can draw some lessons from that have to do with social media. And these are the types of posts that are now, under the current administration, the types of things that you as a business owner can actually do something about. So for example, your policy can say that employees may not speak on behalf of the company without prior written approval. That's a standard clause that had been used previously and is now again protected. You can ban your employees from making negative or disparaging remarks about other employees. That's actually a difference. Previously, something like that would have been interpreted as being too broad and potentially restricting them from criticizing fellow employees in the course of exercising their labor rights. That's not the case anymore. The next is that you may prohibit them from disclosing your confidential or proprietary or trade secret information. That too has always been an important protection. There may have been some tension on whether or not confidential includes things that were protected by labor law, but that's safe now to regulate. Information about the company's clients or customers, you can be forbidden from posting. You can prohibit your employees from misrepresenting the company's products, services, or employees. And you can prevent them from using your logo and trademarks and things of that nature without approval. Now, that is a bit of a relaxing of the rules we've had. And it takes away the default, what seemed like the default approach previously, which is that if there's any way this language can be construed as impinging on labor rights, then it's invalid. We've taken a little bit more relaxed approach. That doesn't mean, however, that all the previous case law is no longer good. So for example, this same guidance from 6 months ago still prohibits clauses that had previously been okay before the social media age. And that includes blanket rules that prohibit employees from making any disparaging or negative remarks about the company. Again, that's the central concern that we have here in this presentation, is employees hurting their employer's reputation online. And to just have a blanket prohibition on that goes too far. Now, you can be more nuanced, and I've written several social media policies to work around these rules. It's the kind of thing that you can take into consideration when you're choosing your language. But it's something that you can't just have a blanket prohibition on. Again, it's similarly criticizing their employer, making inaccurate statements, discussing their wages and their workplace conditions, or prohibiting employees from joining outside organizations. Those are all things that you're still not allowed to adopt a blanket prohibition of in your employment policies. So the direction right now is still in favor of employers when it comes to labor law regulating social media, but there's still challenges to overcome. So I think that's enough for now about labor law. Let's one more topic under the employment heading before we move on. And that relates to a few other topics we have with the current employees, or recently former in this case. So non-competition, non-solicitation agreements as they relate to social media. A lot of our employees have these, and when they leave, we want to make sure that they don't go out and violate these terms by soliciting our employees, soliciting former customers of theirs that are still our customers. And there have been a number of lawsuits filed alleging that that happened in places, especially LinkedIn seems to be a hotbed for this, since it's a professional platform. And posts about the employee's new job and opportunities, things of that nature, have been challenged. Without going too far into the details, the majority of these cases tend to reject these claims. They find that for a former employee to post online about his new job and the opportunities in that new job aren't solicitation that violates a non-solicitation clause. Now, a direct message to someone they ought not be talking to, that's a different question, but just general posts don't go far enough. Now, the solution to this is to be more specific, perhaps, in writing those non-solicitation clauses and address ahead of time, perhaps, exactly what they can and can't do online. But the farther you go in this, you risk that the clause being deemed too broad by a court and being struck down after the fact. So these are balancing acts for you to go through with your counsel when you're writing these agreements in the first place. Just real briefly, one example I've been aware of is an employer that received information about a current employee from strangers online. So if this employee had a beef with someone else or was determined to be an unsavory character by third persons who then reached out to the employer and said, hey, do you see what your employee is posting on Facebook? Or do you know this about him that they said? Sharing this information through social media and of course doing it so that everyone else in the world can read it too, really kind of geared to shame the employer into taking action against this employee. Now, in the particular situation I'm thinking of, the employer considered but ultimately was not required to do anything with the information, such as reporting it to the police, even if you did take it at face value, because it was clear that the group that was complaining had already done that. But they were clearly trying to shame the employer into taking action against this employee, and ultimately the employer could have done that because it was an at-will situation, but chose not to because, for among other things, didn't feel real strongly about giving in to mob justice. If terminating its employees based on the number of dislikes that they get online, that leads to dangerous precedents, and it was something that they chose not to do. So that's an interesting. It's not the type of situation that perhaps many of us have encountered, but that's actually happening out there in real life, and we can expect to see more of it as we go forward. All right. So we've talked about employment law. We are moving on now to a new topic, and that's injury to reputation. And causes of action, legal causes of action that fall under this bucket come in various shapes and sizes. They're called different things. We may think of it in terms of libel or slander. There's even a tort called injurious falsehood. But generally speaking, we, as lawyers, use the word defamation to cover all of these things. And there are defamation laws in every state. They vary slightly from state to state, but the basic principles are still the same. Here in Michigan, there are these elements that you see on the slide that a plaintiff would need to prove in order to prove that defamation has occurred. First of all, the statement has to be false. It has to be demonstrably false, meaning you have to show through objective fact that the statement is actually not true. It's not enough to be a statement of opinion. Even a hyperbolic statement, one that on its face states a fact but is really meant to be not taken literally, that is not a false statement in terms of defamation law. It has to be published to third parties. It can't just be a conversation between the two of you. It has to be done without privilege, meaning that the speaker can't have a legally justified reason to make the statement. Privilege comes up in circumstances such as when you're all part of a group. Maybe you're all part of an association like the SBA, for example, and you then have a privilege to talk to each other about matters that affect your common interests. Or you're part of another association or part of a business. Leaders within a business have a privilege to talk to each other about things that go on within the business. So that may be a grounds on which to avoid liability for a statement made in those conversations. The state of mind of the speaker is important. By default, one has to prove that the statement was made at least with negligence, meaning they should have known better, basically. If the person being spoke of is what we call a public figure, which means they're in the public eye, then the statement has to be made with actual malice, which is a term of art, meaning you have to know it was false and know for a fact that was false when you said it, and have intended for it to have hurt the person's reputation. Very high threshold. And it has to hurt the person's reputation. Yet damages need to be shown, unless it falls into certain categories. But leaving that aside, we're looking for injury to reputation to a person to make them to lower their estimation in the eyes of others. Or if you're a for-profit business, you can be defamed as well, and that's what we're primarily concerned about here. And to show injury to the reputation of a business, you need to show that customers, business people would be less likely to want to do business with the company. They would have a decreased perception of that business's professionalism or reliability, or any of the factors that go into making that an attractive business. Even nonprofits have the ability to prove defamation, that they've been defamed, and that is evaluated by the things that make a nonprofit valuable, whether people would be less likely to donate money, for example. And if you can show that, you can show that the nonprofit's reputation has been injured. Now, I've briefly summarized these, so you can obviously go much deeper into these details, but the reason why there are so many of these tests, so many of these thresholds, and the reason why they're so demanding are the elephant in the room, which is the First Amendment. And as I'm sure you know, the First Amendment protects the right to speak, right to speak freely. So that particular principle is so ingrained in our law as a society, in our civic society, in our Constitution, that it is the overwhelmingly default principle whenever we evaluate whether someone's speech is unlawful. So before we can use defamation laws to punish people for speaking about us, even if it's distasteful, even if it's arguable, debatable, disagreeable, none of that type of speech in and of itself is anything we can use the legal system to do anything about, because our presumption is we want to encourage people to speak. The courts will tell us that the solution to speech is more speech. If if someone offends you, you respond to that offense. You don't necessarily use the power of the law to stop. Now that's the default. That's why defamation is hard to prove. But obviously, there's a lot of defamation litigation that happens, particularly nowadays, for more than one reason. But social media has certainly made offensive speech more accessible, and it's made it more commonplace. And so we've seen an uptick in defamation litigation as well. That's not to say that businesses can't prove defamation. They certainly can. It's just understand going in that this is never your first choice. And it's never the easiest choice, but sometimes it's the right choice. So examples, just from either personal experience or experience of those I do business with, tweets attacking a company's employees, suggesting that they've engaged in illicit relationships or untoward behavior. That's an especially hot topic nowadays with the Me Too movement, and we encounter a lot of that online. Alleged against local businesses and their leadership. Sometimes the social media review sites such as Yelp or Piss Consumer, or things of that nature, we see a lot of reviews on there that are both disparaging and oftentimes false. Sometimes they're not false. I've actually represented people on both sides of that issue, both consumers that have complained on Yelp and then were bullied by the company that they reviewed, threatened with a lawsuit based on their negative reviews, which they had every right to post, as well as companies that are targeted on Yelp and other sites with reviews that are obviously false. They're fabricated by unknown persons in order to damage the reputation of the company. And each side has rights in those situations under defamation law. One particularly nasty situation that my clients have had the misfortune of encountering more than once are the cheater websites. So there are any number of websites out there that are dedicated to anonymously outing people who are unfaithful to their significant others. And more than once, an employee or officer of a client has found their name, their picture posted on one of these sites, alleging that they are a cheater when it's not true. And in each circumstance, it's turned out that the information was posted by someone who had a beef, had a vendetta against this person, and used these sites in order to target them. That's something that happens and something that we can do about. So that's just a handful of examples. Let's talk about what the responses to some of these situations can be. Well, for one, my number one recommendation in terms of just quantity of situations in which this is the result is do nothing. As frustrating as it can be, more often than not, a post that gets under our skin, that annoys us, is just a flash in the pan. There's so much of this stuff online, so much of it on Facebook. It'll be replaced by new text in 30 minutes that other people will be looking at, and that it's seen by few enough people that usually it doesn't pick up any steam. And the risk here is what's become known as the Barbra Streisand effect, after the person who popularized it by overreacting to a negative post. And as a result, the post ends up getting far more attention by the public at large than it otherwise would have, because now news media pick up on it, other sources pick on it, it starts to get retweeted, reposted, reshared, commented on, and the story takes on a life of its own, whereas if it's just ignored, it goes away of its own accord, and nothing really changes for you and your business. Now, it's always important to keep your eye on the post to make sure that it goes away, make sure that nothing else is said on it. But oftentimes, as opposed to taking action, doing something, sparking emotions on the topic, it can be often just as good to let it go. If we do something, sometimes it takes nothing more than to ask, to reach out to the person, maybe with the lawyer on your behalf, maybe directly, and have a conversation. Where did this come from? Can we get rid of this? What can we do to solve the problem? This is particularly true in consumer situations. To say, look, I'm sorry you're disappointed by your experience. Can we do something to help you out? And the problem becomes de-escalated. It's more serious than that. Oftentimes, you don't even have to interact with the person. And this is a solution that I'm actually a little surprised, but be that as it may, that folks don't actually recognize how robust of an option this is. Every platform that we deal with, whether it's Facebook, Twitter, or the like, they all have their terms of use, their policies on the site that determine the rules under which you can use the sites. And every one of these, in its own particular way, forbids things like harassment, derogatory attacks, you name it, whatever synonym you want to use for that type of language. It's prohibited by the language, and each one of these sites has an automated process, a form that you can fill out, click the right buttons, click the right categories the speech falls under, and if you submit it, they'll take a look at it, and oftentimes it's taken down. Sometimes it helps to have somebody who's done this before to choose the right language in describing it, but often it's something that you can do just as effectively yourself in clicking the buttons and letting them know about this post. And if they take it down, then there's no intervention, there's no involvement from the other party. You don't have to interact with that party, and it may be reposted, it may not, but usually they take the hint and don't repost the information. If a direct confrontation is warranted, you can make you send out a letter from a lawyer. Oftentimes the offended party wants to reach out directly, but if you've already had that conversation and it hasn't gone anywhere, chances are that saying it again isn't going to change the result. So I've never I've been surprised, I suppose, over the course of the years, just how powerful the effect of a lawyer's letterhead can be. Making the same request in a more formal manner like that conveys a lot about what you're willing to do to enforce your rights. Now, whatever threat you make, you need to be willing to follow through on. So it's important to choose your words carefully in a lawyer letter like this, so that you're not you're biting off more than you can chew, or undermining your own credibility of your threat by not following through on your raucous language. But as long as you are direct and say, this is exactly what's going on, this is why I want you to do something about it, this is what you risk if you continue in your course of action, that's surprisingly effective. In a defamation context, if that's one of your claims, it's important to include in that letter as well a retraction demand, because that's a prerequisite for certain damages under the defamation law. When appropriate, and it's not always appropriate, but when it is, make sure to copy the person's employer. In many of our business situations, this person is employed by someone else and can at least arguably be said to be acting on behalf of their employer as their agent. And if that's the case, it's worth it to let the employer know exactly how their employee is behaving towards your company, and chances are they may intervene themselves to shut their employee up. Sometimes lawsuits are warranted. Again, not nearly as often as some of these other options, but sometimes it's called for when the post is serious enough. And we'll talk about other situations even beyond defamation where the seriousness of the post may warrant such action. Here I've suggested suing the poster, the person writing the content, and not the website. There's a reason for that. Federal law, specifically the Communications Decency Act, Section 230, deems websites to be not the speaker of content like this. And there are hoops they have to jump through, but leaving that aside, the basic presumption is that when you find content like this on a social media website, the social media website itself isn't responsible for it. They are the platform, they're not the speaker. So they're not, for example, liable for defaming you or injuring your reputation or anything else. They're just the medium in which it was posted. So your beef is against the author, not the website. And oftentimes you won't know who that person is. That's okay. You can file a lawsuit against John Doe. The advantage of doing that, again, this is only under certain circumstances. The advantage of doing that is that once you have a lawsuit in place, you gain subpoena power. Subpoenas allow you to dig up information and force companies to give you information that they otherwise would have no duty to give up to you. Now, I've used this tool on a number of occasions to track down anonymous speakers through targeted subpoenas, first to the website to see you can get information, for example, on the name that they use, and sometimes that's a real name, oftentimes it's not. You can get the IP address that they use to log into the social media site. Well, you can track that down, and through a number of steps, you can usually use that meta information to find who your defendant is. Private arbitration is a solution that's unique to these cheater websites. So they understand, the people who put these websites understand just how motivated the folks being discussed are to get that information taken down. And they take full advantage of all their rights under the Communications Decency Act. But what they do is they offer this choice of arbitration through a private neutral service. I suspect often a service that they are in cahoots with because it's expensive, and I wouldn't be surprised if these websites are getting a cut, but I don't know that for a fact. But in any event, they give you this convenient option of paying a few $1,000s to this private arbitration group to resolve your claim for you. And if they determine that the post has no merit or has no support, then ultimately the website's willing to take it down. Now, I've gone through this process. It's slow, it's a bit arduous, but often, usually, it does work. There are other sites that will pick up the information. Some of them are offshore and more difficult to deal with, but it's something. And then as a kind of a mop-up action after the fact, or as a preventative step before we run into defamatory content like this. There are reputation management companies out there and steps that you can take on your own to try and ameliorate the effect of some of these posts. Basically, what it amounts to is swamping the internet with positive information about your company, so that the search results on Google go to that information rather than the negative information that you'd rather not come up. You give the search engine so much to choose from that the offending content gets pushed down in the results, and oftentimes, as a result, is just not seen by as many people, even though it technically still exists. All right, so those are the first two buckets, employment law and defamation liability, that we look at when we're deciding what to do about vengeful posts and the type of rights that the vengeful posts infringe upon. The third is intellectual property. And these come up in very specific circumstances. If your IP rights have been infringed, you're likely to know it. It's not a circumstance where you're worrying about, well, whether your reputation was impacted. Your IP either has been infringed or it hasn't. Now, these types of claims are useful on their own. For example, if your copyrighted material has been posted online, you can use the copyright law to get it taken down. But they're useful as tools to get other sorts of content down. So, and vice versa. So a defamatory post, for example, if it happens to have a copyrighted picture associated with it, you can get that picture taken down. And as a result, you can somewhat neuter the effect of the defamatory post, even if you can't get the content of that post down itself. Conversely, if there's an intellectual property right that's affected by a post that you can't necessarily do something about directly, but it's infringed. What's said about it in that post is harassing or otherwise in violation of site rules. You can use those rules to take down the infringement that you're really concerned about. So what type of intellectual property rights are at issue? Well, there's copyright. Copyright, again, just skimming through the surface of these issues, protects creative expression, original expression. We're talking about images, text, music, those sorts of things, photos. Those are all protected by copyright. They're inherently protected, meaning that once you make them, you have copyright in them. But oftentimes, in order to prove that you have those rights, you need to have registered them with the federal government, with the Copyright Office. Good news is that's easy and it's cheap. So it certainly encourage registering upfront the creative materials that you have and that are at least important to you. Now, an advantage that you have in the copyright aspect is that there's a law called the Digital Millennium Copyright Act, or DMCA. Been around for 20 years, and what it did was create a mechanism, a legal mechanism websites are required to follow, and that it makes it easy to take down copyrighted content. If you've heard of a takedown request, you're usually talking about a DMCA copyright takedown request. What it does is if you identify to the website owner specifically enough the information that you're concerned about violates your copyrights, they will react to that by taking the material down, assuming that the other side doesn't come back with a justification. There's a process that then happens by operation of law whereby most of that content is usually taken down. It's a very effective tool. Sometimes it gets abused, but for purposes of our conversation today, it's a very effective option when you have it. Now, on the trademark side of things, we don't have the same thing. There is no DM Trademark Act. The trademarks are a different set of rights. They were talking about our logos, our slogans, things we use to identify our businesses and our products. And it can be more difficult to prove a violation of these. That doesn't necessarily mean that they're not enforceable. It's just that there's no automatic procedure in place like there is with the DMCA and the copyright side of things. Now, I have been successful in my own experience in persuading sites like Facebook that a particular image or logo violated my client's trademark rights, and they've agreed and taken that down. But it's a more involved process, and so it's not the most successful route in terms of taking down material from social media. Again, though, if someone's out there using your trademark in ways that you object to, and they do it in a way that's derogatory and offensive, racist, something like that, some way that also violates the terms of use, you can use those terms of use to get the content taken down and thus solve your trademark problem. Trade secrets are something that's been increasingly thorny problem on social media because it's an easy way to publish to the world your proprietary information. The value of a trade secret comes from it being secret. It's our proprietary methods, our knowledge, formulas, and once that information gets out, it's no longer as useful to us. So because it's so easy to publish things online, we often find social media conversations coming into trade secret issues. So that is there again, there's no automatic procedure for that, but there are statutes both on the federal and the state level that provide for rapid response if you pursue a trade secret lawsuit that can solve those problems. And companies are often protective, extremely protective of these things. I know, for example, examples of GM employees who have been terminated for posting pictures of yet to be published vehicles, even if they were jokes, even if they were not actual vehicles. No tolerance for that sort of thing. The right of publicity I'm going to touch on very quickly, and all that is the right to control the commercial exploitation of your own identity or your own likeness. Again, this is a relatively obscure area of law that has seen a lot of growth due to social media, because social media makes it so easy to use images of other people and to do offensive things with them. It doesn't prevent you from using a person's name or image for any reason. It applies primarily to commercial uses. So we see celebrities, we see companies objecting to the way that their founders or their spokespeople are being portrayed. But again, for this purpose, it's good enough to know that this is another tool in the toolbox to get information taken down. Last bucket, which is there's not as much to say on because it's pretty straightforward, but we'll touch on it because it comes up so frequently, and that's invasion of privacy. Now, some of the rights we've already talked about, specifically defamation and the right of publicity, are also rights that stem ultimately from the broader law of privacy. But when we think about our privacy being invaded, these are the two causes of action that generally come to mind. This is what we're really thinking about, and that's publication of private facts and intrusion into seclusion. In other words, publishing to the world things that are nobody else's business but yours, and that usually has to do with health information, sexual activity, things of that nature that are profoundly intimate, that have no public utility to them. And intrusion into seclusion, hidden camera footage, for example. That's the sort of thing where it's where there is a recording. It's also called eavesdropping in certain circumstances, where a recording is made and information is gathered from a place that the public has no right, no legitimate interest in being. And we see this, of course, in social media, especially with the rise of video chats and other audio-visual forms of social media. Ultimately, the fundamental inquiry in any privacy debate is the reasonable expectation of privacy. And that's an objective evaluation, and it's a case-by-case evaluation. When the court says, under the circumstances of this particular case, did the person actually have a right to privacy? Was it reasonable for them to have expected this information to be private? When we're talking about social media and information that has been shared on social media, the vast majority of courts are holding that if it's shared online, it's not private. And so sharing that information, again, isn't going to invade anybody's privacy. For our circumstances, though, as business owners, we can certainly have certain circumstances, and there have been circumstances where information about people in the workplace is being shared, and that can be an invasion of their individual privacy. It's also helpful to remind ourselves that in Michigan particularly, there's a statute passed back in 2012 that forbids employers from asking about their employees' personal social media activities. So you're not actually allowed under state law to require a job applicant, for example, to produce their personal social media, or for your current employee to give you access to that media. So there are privacy concerns going in that direction as well. Now, each one of these topics that we've breezed over today, and I hopefully gained some information, understanding of, are subjects that we can go much deeper into. But we're nearing the end of our hour, and that is the sum of the presentation that I put together for you. We have about 10 minutes left if anyone has any questions.
Thank you so much, Brian. Some really good stuff in there. A lot of information that I was not aware of, so very thought-provoking. I don't see any questions at the moment. I guess one of the questions I guess I would like to see, in your experience, what do you see most, in the small business world as a small business owner? What are the big things that you see are the mistakes that employers make in this area?
Well, one of them I hinted at, which is overreaction. As disagreeable and irritating as a lot of the content on social media can be, we make it worse oftentimes by reacting to it.
Mm-hmm. Yep.
Yeah, and I've seen, thankfully not personally, but I've seen close at hand what happens when lawyers get involved and they overreact. So one thing to keep in mind whenever you're reacting to someone in writing, whether it comes from you or a lawyer, is that you have no control over what the recipient does with that writing. So a lot of times, if you are demanding that another person take action or take certain things down, they can respond by reposting your threat on social media and trying to shame you in response. And sometimes that backfires pretty spectacularly.
Yeah, well, that could go public. Yeah, it's good advice. Great. Well, that was good. Any other questions from our attendees, our participants? Thank you. I enjoyed it. Learned some information I didn't know. I appreciate it, Brian. And again, we will take this recording and we'll put it live on our website, or we'll put it on the website. It'll be out there next week. And please share it with other folks. If you have any questions, you're welcome to reach out to Brian directly. Brian, we can reach you at the Warner Norcross Judd office. Which location would that be?
Well, I have offices in both Southfield and Macomb County, but we're pretty easy to reach no matter where.
Great. Excellent. Warner Norcross Judd. All right. Well, thanks so much. We appreciate it. Everyone have a great day. Safe travels. It's snowy down here in Southeast Michigan, and have a wonderful Thanksgiving to everyone. So, all right. Take care. Bye now.